Hello, everyone, and I want to welcome you to the Subrogation mini-series, Episode 2, the No Fault section. My name is Tiffany Williams, and I am attorney for Weltman, Weinberg, and Reeves. I work in the Detroit, Michigan office, and I handle exclusively subrogation for our clients. I handle no fault actions, workers' compensation actions, property damage losses, fire losses, water losses, or any other actions that our clients may have against some individual that's responsible or company that's responsible. Today we're going to focus on the No Fault Act and the changes that recently occurred within the last few years to that act and how that impacts our clients. So let's go ahead and get started. So let's talk about what no fault law is as it relates to automobile accidents. So there's two type of states. There's a traditional state, which is sometimes called a tort state, where a person who is injured in an automobile accident can recover from the person who's responsible for those injuries and the damage to the vehicle as well. In contrast, a no fault state is one where an injured person can recover medical expenses and loss of income from their own insurance company, regardless of who's at fault. So that's a major difference between a tort state, which is a traditional automobile state, or a no fault state. There are several no fault states or quasi no fault states. I've listed those here in exhaustive list on your screen. We're going to focus more on Michigan today, but there are some states that have you have the ability to elect to be governed by no fault laws, or it's required, such as in Florida. And then if you contrast a state like Florida and Michigan, Michigan has a more expansive no fault scheme versus Florida. So they're all different. They have different types of no fault laws, but the principle is still the same that when you're governed by the no fault laws, you go back to your own insurance carrier for your personal injuries, regardless of fault, and you do not go to the tort fees or the other insurance company or person for those damages. So let's look at a brief example. So let's compare the no fault system with the traditional system. So consider, for example, a two-car collision involving cars A and B. Assume that B was at fault and A and B are both injured. So let's look to the tort system first. So A's medical expenses, rehabilitative expenses, lost wages, and pain and suffering are all recoverable from B or B's insurer. So the other person that was involved in the accident. If we look at B, um, B's medical expenses, rehabilitative expenses, lost wages, pain and suffering are all recoverable against B's own insurance company. That's in a traditional tort state. Recovery under a no fault system is a little bit different. So we look to A first. A's all of A's medical expenses, rehabilitative expenses, lost wages are recoverable against A's own insurance company. A's pain and suffering may be recoverable against B. Now, it's important to remember in these examples that A was not at fault for the accident. A still goes back to their own insurance carrier for all of their economic damages, which is kind of what I listed: medical, lost wages, goes back to their own insurance carrier, regardless of whether they were at fault or not. And they are still able to recover pain and suffering from B or B's insurer. And under the recovery under a no fault system, B's medical expenses, rehabilitative expenses, lost wages, pain and suffering are recoverable against B's own insurance company. So that remains the same. So whether it's a tort state or a no fault state, the at fault person still goes back to their own insurance carrier. But when it's a tort state, the non at fault person can go against the tort fees or the at fault person, and in a no fault system, A can recover from their own insurance company, but not from the other insurance company. So let's look to Michigan no fault. So Michigan has one of the most expansive bodies of law regarding no fault. The law discusses not only uninsured motorists, It discusses when an individual will be covered under the no fault scheme and what the requirements are, and also provides an order of priority in which insurance company is supposed to pay those first party benefits. On May 30th, 2019, Governor Whitmer signed a no fault auto insurance reform bill. The previous law required that all Michigan drivers carry unlimited medical coverage. The new law allows Michigan drivers to choose a level of medical coverage when their policy renews after July 1st of 2020. Now, it's important to note that um, any accidents that occurred before that July 1st, 2020 date will not be affected by the new law. It is only those accidents that occurred after July 1st of 2020 that would potentially be affected by the new law. So let's look at the different levels of coverage that are now available to drivers in Michigan. First, a driver can still select the unlimited coverage, which was previously the mandated requirement in Michigan, or they can select a lower tier coverage, which is $500,000 per person per accident. And this relates to the PIP coverage. So this does not affect any third party benefits. This is exclusively for PIP coverage. They can also select $250,000 with either exclusions or no exclusions. So if you have excluded driver or some other qualified exclusion, you can select the exclusions, or you can just have a typical policy with $250,000 being your PIP cap. You also can select $50,000 per person, but you have to be enrolled in Medicaid, or your spouse has qualified health coverage. And then in order to have the selection of no PIP coverage available, you have to be enrolled in Medicare Parts A and B, and your spouse and a resident relative has a qualified health coverage that you would be able to utilize if you were involved in a motor vehicle accident. So how does this affect the subrogation claim? Well, one, it imposes liability on the named insured, the insurer, and the agent. So with qualified health insurance, the person who's getting the policy is required to provide that information at the onset of the application. If there is a misrepresentation made regarding having qualified health insurance, that could be a reason for a cancel of the policy to inception, and there's a subrogation claim that can be had against that insured for that misrepresentation at the application stage. In addition, the insured is required to disclose if qualified health insurance is lost. So, for example, if an individual loses their job and they do not have qualified health insurance from another carrier, then they're required to provide that information to the insurance carrier, to the auto insurance carrier, so that their policy can be adjusted accordingly. Failure to do that could result in a denial of the claim and potentially misrepresentation with a cancellation back to the renewal of the policy, depending on when that occurred. In addition, it imposes liability on the insurer and the agent. It's not enough for the insurer and the agent to just give the potential insured a policy. They have to disclose the risks and benefits of the particular coverage that's selected. So a $500,000 coverage or no PIP coverage, they have to disclose that at the initial onset of that application. And again, this takes effect on policies acquired or renewed after July 1st of 2020. Now let's talk about the altered priority rules. Vehicle occupants not otherwise insured with PIP coverage will draw benefits from the assigned claims plan and not from the vehicles they occupied. This is a major change with the reform. Previously, individuals who did not have coverage, either through their own policy or resident relative or spouse, could draw from the insurance of the owner or driver of the vehicle they occupied. That is no longer the case. That was removed as a result of the reform. So they have just two options. The first two options remain the same. So they can go back to their own policy as any policy where they're a name insured, a person named on the policy. or they can go to their spouse or resident relative. And I like to really say a domiciled relative, but nonetheless to a relative that they reside with at the time of the accident that complies with the Michigan no fault law as far as being a resident of that home. A pedestrian or bicyclist not otherwise insured with PIP coverage draws benefits from the assigned claims plan, just as the vehicle occupants we discussed earlier. So they go back to their own insurance policy, then they go to a spouse or resident relative, and then if there's no coverage there, they go to the Michigan assigned claims plan. And then lastly, a motorcyclist who draw PIP benefits pursuant to the same order of priority they did under the previous law. Out of state residents are no longer entitled to PIP coverage for injuries sustained in Michigan unless the vehicle is registered in Michigan and insured in Michigan. Again, this is a change with the reform. Out of state residents who operate a motor vehicle in Michigan for more than 30 days over a year period must buy a no fault policy. This remains unchanged. But it's worth noting that if an individual who uh, it resides in the state of Michigan for more than 30 days and operates that vehicle for more than 30 days within a year, and they do not um, buy the Michigan no fault insurance as required, they are considered an uninsured motorist. So that is a potential subrogation action that's available to insurers. An out-of-state resident may recover medical expenses from a negligent Michigan driver without monetary limitation if the out-of-state resident sustained a threshold injury. This is an insured Michigan driver, but it's unlikely to occur, and the uninsured motorist benefits would still pay. So with priority disputes, let's talk about the statute of limitations. The time to commence a legal action and the time limitation to recover benefits is told from the date a specific claim for payment of benefits is made until the date the insurer formally denies the claim. The tolling statute only applies when the claim is pursued with reasonable diligence. So previously, there was a strict requirement that you had just the 1 year to pursue those bills against a higher priority insurer that was responsible to pay for the injured party's PIP benefits. With the reform, the statute of limitations is a little bit longer if the claims have not been denied. So you're looking for your formal denial from that other carrier who is responsible for the bills and is a higher priority insured. But you have to show that reasonable due diligence was engaged in order to recover those PIP bills from that higher priority insured. If a bill is not provided to an insurer within 90 days of the date of service, the insurer has 90 days instead of 30 days to issue a payment. Again, that's a big difference as well. Typically, their penalties start to apply after the 30-day mark, but if the bill is not presented timely, you get 90 days instead of 30 days. Another change is to the IME or independent medical evaluation. When an insurance company requests a medical evaluation of the injured party, the physician must have a specialization similar to that of the injured party's treating physician, and that's a change under the Reform Act. The last change to the Reform Act I'm going to discuss in this presentation will be to attendant care. Under the new Michigan no-fault law, auto insurers are not required to pay for more than 56 hours per week of no-fault in-home family provided attendant care. This limitation applies after July 1st of 2021. So that concludes our presentation on the No Fault Act. Stay tuned for upcoming episodes. The third episode of this series will be released at 12 p.m. on Thursday, July 14th. This episode will feature attorney Cameron Dean and shareholder Mike Doherty discussing non-performing judgments. If you have any questions, their phone numbers are listed on your slide currently. And if you have any questions for me, feel free to call me. Again, my name is Tiffany Williams. My phone number is 786-3162. And my email is tnwilliams@weltman.com. If you have any questions regarding more expansive education on the No Fault Act, the changes, or any other aspects of subrogation, feel free to contact me. Or if you have any suggestions for any upcoming webinars, please feel free to email me as well. Thank you, and I hope you have a great day.